Okay, I'm recording this now because I said I would post it onto YouTube for people who can't attend to be able to watch. So this concept of implied bias, it's really important. I had a situation a few years ago where the other side had a document examiner. When the other document examiner went first, the judge said to the attorney who retained me, I have to let you know that when I was in private practice, I used to retain this document examiner frequently. Do you mind? The attorney who retained me said he had no objection. I thought to myself, why am I even here? And that turned out to be the case. Apparently, even when the judge made his ruling, he alluded to that he knew the other document examiner, and there were holes and problems with his testimony. I pointed that out to the attorney who retained me. He said he wouldn't go after the other document examiner on those issues. I don't know for certain why, but it could be that he had to appear before that judge in future cases. I don't know that. But when we talk about this implied bias, it can appear in many different instances. So we have to look and say, are there, even from the jurors, have the jurors experienced situations such as this case in the past, and that didn't come out in voir dire, and they're sitting on a jury, and based upon their experiences, they have a bias in one way or another on the case. So we get to the judicial bias and the judge's bias toward one of the parties, which is similar to what I just discussed. Notice in this diagram, which side is being weighted down more. Now, it's important, though, that in our legal situations that it's not a majority rule, which is what this is showing, that one side can have sufficient evidence that outweighs what the majority thinks. We want it to be decided on the issues, not on what a societal approach. So when we look at this, we have to make sure that the judge is being fair to both parties. But when we talk about understanding bias, there are many biases that we have. One of the biases that we have as document examiners is the question of, do two people write alike? One of the theories in handwriting identification is that no two people write alike. I have a question. Is that something that can be proven? In opening the question, do you accept that theory, that no two people write alike? Any input? Any comments?
Seeks to reduce risk.
Well, the theory go ahead.
Well, we all do have biases. And sometimes handwritings do look alike. So we have to recognize that we have to look at the other side of the coin.
Well, is it possible that two people write identically?
No.
No.
Highly unlikely, because you're talking about two people. We're talking about not just millions, but billions of people.
And given we're talking about millions of people or billions of people, isn't it probable that two people write alike?
I would have to say yes.
Right, and that
in the larger framework of
right.
possible writings, although
Right.
may not be possible in this particular framework that we're working on in a case.
And what that comes down to is, where do we collect our samples? And we have to ask from the population of which we potentially could have written, is that true? What about snowflakes? Is it possible that two snowflakes are identical?
Say that
I'm
again.
not an expert on snowflakes.
Well, the question I asked is it possible that are snowflakes unique?
With handwriting, I think we need to take in consideration the class characteristics, what I'm going through right now in the case. There's the similarities because of class characteristics, but the uniqueness of each individual's handwriting, their own unique characteristics, divide and separate them from others.
And is it possible that two people have the same unique characteristics?
Not all of them, Mike. They might assume some, but not all.
Well, we've all heard the theory that no two snowflakes are identical, right?
Right.
Which can't be proven.
Yes, it can.
How do you figure it can?
Right there. Photographs of two snowflakes, one from 1963 and the other from 2010. They are identical, and which means that in 2010 it was proven that snowflakes are not unique. So from that perspective, the whole idea that handwriting is absolutely unique amongst everyone is a non-provable theory. And that's something where we come into bias, and that's where we have to be careful when we're doing our handwriting comparison, is that what we're looking at, we can never be 100% sure. That's why we have opinions. We don't have conclusions. And that's something where I would take issue with the standard, which says conclusions, or expressing conclusions. You should say expressing opinions.
Well, I think conclusions can be a word that can be used with opinions. We come to conclusions based, and I think they can be, a conclusion can be an opinion, but we also can't know someone signed it unless we visually see that they signed it.
Right. So therefore, it's an opinion. It's not a conclusion, because a conclusion means it's the end. It's possible that if we had additional exemplars, if we had additional evidence, that our opinion can change. So we have to be careful about that. So we get into this concept called cognitive bias. Cognitive bias is at the subconscious level. There was an author, I forgot to put the citation to give proper credit, named Lauren, and this was in writing in business theory. The cognitive bias is the faulty pattern of thought resulting in the misapplication of judgment heuristics, which means heuristics are a rule of thumb. It's a way of doing things. And the problem is that on a subconscious level, we may, in fact, have certain biases we don't even recognize. There's quite a bit of research theory that shows that, in fact, we're not even aware of many of our biases. We're not even aware of many of the ways we think and we do things. And it's up to others to point that out to us. So Werner Heisenberg said, an expert is someone who knows most of the worst mistakes that can be made in the subject and how to avoid them. Any thoughts about that? We're all called experts. What does that mean?
I like that quote.
Yeah. So we have these things, what's called implicit biases. And if you're interested in more on implicit bias, Jerry Kang from UCLA wrote a very, very interesting article, Implicit Bias in the Courtroom. And what he says is that implicit biases are attitudes and stereotypes not consciously acceptable through introspection. And that's the point he's making, is that these implicit biases aren't even available to us. We don't even know about them. And something he points out in his research report is that he was looking at it in terms of biases and how are judges and juries biased towards certain types of people, especially in racial situations. Something that he found out is that in situations where a person is on trial, that certain races and ethnicities will be given harsher sentences unless it's a high-profile case. What he found is that in high-profile cases, that people tend to be, judges and juries, tend to be more conscious of their potential biases and do what they need to overcome them. Yet in non-high profile, people, they allow themselves to, they allow their implicit biases to come forward. If any of you are going to attend the FIWA conference here in San Diego in April, one of our speakers was one of the consultants on the George Zimmerman case, and he'll be talking with us about what went on with that in terms of biases and so on, which would be very interesting. So examples of cognitive biases are, and we'll get into each one of these, is framing effects, failure of invariance, anchoring and availability heuristic, contextual bias, overconfidence, and confirmation bias. And what the National Academy of Sciences, we saw a picture of that on the initial slide. Back in 2009, and this is something, if you haven't read it, you need to read the NAS report. If you were to go to Google, type in NAS report 2009, you can download a copy, a PDF copy from National Academy of Sciences. Something they said is cognitive biases are not the result of character flaws. Instead, they're common features of decision-making, and they cannot be willed away. The point here is that they're innate in us. It's not a flaw. It's based upon how we think, how we've been raised, how we've been educated. And because of that, that's one reason why it's valuable to have more than one decision maker. But yet motivational bias is very deadly. Motivational bias is a situation where someone does something because they're motivated. As an example, let's say a document examiner has a choice between agreeing with what the attorney said, this is what I'm looking for, this is what my client said, versus giving an opinion antithesis to that. The document, if we looked at it from a bias perspective, the bias is to give the attorney what the attorney is looking for. Because then we have a chance of going to testify, which means to make more money and so on. Yet we know that our loyalty is to the evidence. It's not to the attorney who retained us. So therefore, from a motivational perspective, we need to make sure that we do not get motivated to give the opinion that we believe is desired. Now, I had a case, it was an interesting case out of Pittsburgh, Pennsylvania. I guess it's 2 years ago now, it's 2015. The attorney gave me no indication whether he was hoping the person wrote it or didn't write it. When I told him that the person did sign the letter, he said, I was hoping you were going to tell me he didn't. But then I added to that. I said, what it shows, when I look at it from a statistical perspective, and we'll show you some ways of doing this later, the signature comports with his recent signatures, not from back when the letter was allegedly signed. The attorney approached the other side with that information and got what he said is a big settlement. I don't know how large a big settlement is, but it was a med-mal situation, so I'm sure it was very, very big. And that's where we'll see how we can get away from bias and use statistics and use quantitative measures in order to get away from the subjectivity. Adam Goldine, who he's a psychiatrist up at the University of California, San Francisco. So, Reed, you can go visit. Or no, you're not. You're in Hawaii.
Yes.
But if anyone's in San Francisco, you could go over to UCSF. And this is a paradigm that Adam Goldine came up with, which is really good. It shows on the top, we're seeing motivational bias. On the bottom, we're seeing cognitive or subconscious bias as the paradigm. And notice that on the subconscious level, our professional background and genetics and just the way we've been brought up causes us to think in certain ways. Whereas if we look at the top, our personality, the situation, provocations, and so on, may cause us to act in certain ways and motivate us to take certain actions that we otherwise might not have taken. So oh man, you don't have the handouts on this, so we'll skip this one. But motivation can affect jurors. Motivation of the way they think, the motivation of the way they think that society wants them to behave. What is their motivation from their ethnicity, from their racial, from their religion group versus the defendant? Do they have motivations to say that people of this particular group tend to commit certain type of crimes, so therefore it must be? What's the motivation that we may have if we're given influence by the in terms of contextual bias, if we're given information by the attorney that says, you know, this person has been convicted of fraud before, this person has served time in jail, and this person is suspected of committing fraud on this case.
I gotta go out. I'll be right back.
So
Anybody turns on that camera who's looking at
in a situation like that,
You're looking at the inside of one page.
there may be underlying thinking that is now biased us.
Come on, box.
Even though, can people mute their phones or mute their computers? There's a mute button on your computer because there's a lot of background noise. So when we look at jurors relying on real life, we may have situations. I'm giving a presentation to an organization called the Association of Legal Nurses. And something that one of them told me is that nurses have to put together what they call patient plans. And the problem is, many of them who write them never use them. And another situation, I had a situation about a year and a half ago, had to go to the emergency room after a car accident. They said, well, what's your pain level? I said 5. I was able to walk in. I wasn't falling apart. Hour and a half later, I went up to the registration nurse and said, well, how much longer is it going to be? So we take people based upon their need, and everyone else is saying they're a 10, you're a 5, so you're waiting. I learned how the game is played. It was a bias, because if I had said I was a 10, I probably wouldn't have had to wait an hour and a half to go see someone, another hour and a half before I got to see a doctor. So when jurors rely on representations of real life also. That was a representation where in real life, I said I was a 5, other people said they're a 10. And when we are giving our testimony, that's one reason why we have to give it as stories. We have to tell not just the facts of the case, yet we have to tell a story in order to get the jurors to understand, because that's what they rely on, is real life. Make it so that they become part of it. Use the word you oftentimes when you're telling your story, because that brings them in, makes them part of it, rather than just taking a dispassionate third party approach. The other part is, and there's quite a bit of research showing this, that jurors make their decision based upon what they consider to be a plausible story, not based upon the facts. That's something that we have to take into consideration, is that the story that we give has to be plausible. It has to be something the jurors can understand and relate to. It has to become part of them, and which is something important. We talk about bias in the laboratory. ASTM, in 2010, I did a search of the ASTM journals for laboratory bias. Found 96 hits. In 2009, ASTM published an article describing laboratory bias, and something that was very interesting is they said that I believe 80% of the 80% of the laboratories they surveyed showed laboratory bias, and 20% of those showed what they called severe laboratory bias. And some of this bias was that the forensics laboratory, saw themselves as an extension of the prosecutor. They examined the evidence from the perspective of what the prosecution told them, rather than having it be a blind examination where they were just given the evidence. They weren't told this is from our suspect. They were told how the evidence was collected, from whom, and so on. But so how does laboratory evidence and bias affect us? Well, just by being told by the attorney, we're on the defense, or which side we're on, then that will tend to bias how we look at the data, whether we want it to or not. There's plenty of evidence that shows just being given information causes us to change the way we think about the data and the way we collect data. So when we say consider Reisinger and Sachs, we document examiners like to pillage them, but the point is, they're right about a lot of what they say in terms of bias. Now, having said that, if you read some of their reports, they also show bias. So we tend to sometimes think of cognitive bias as being expressed as stereotype. How we stereotype certain types of writers. We stereotype writers that you come from a certain place. We stereotype writers who learned a certain writing style and copybook. And from that perspective, we may tend to classify our writers or that we know someone had certain ailments. we tend to have certain stereotypes that a simulated writing will be slow, it will have stops, and so on, but it doesn't always. Some people are good simulators. We have to think beyond that. So this is where I was talking about for the patient care plan earlier, in terms of that they're all different. If we do searches on the internet, we can find that nurses have all different types of patient care plans, but they don't necessarily use them. I was talking with one nurse who said, yeah, we have patient care plans, but we use the same one for everyone. That's a bias. If someone's doing some clicking or something, can you
Yeah,
either
it's distracting.
what's that?
It's very distracting.
Yeah, can you either stop the clicking or put on mute?
Maybe it's the unidentified person.
What's that?
Maybe it's the unidentified person.
Maybe it is. I was just looking on here to see if I had a mute. So I'm going to hit.
Can we remove that person? That blank screen? It might just be somebody signed on and walked away.
Could be. I don't know how to do that. This one, a guest. I'm going to just hit remove on a guest.
Okay. There you go.
Yep. That was it.
Perfect.
Okay. So whoever was joining us surreptitiously is no longer here. Okay, so going back to our presentation. We know that document examination is considered one of the pattern recognition forensic disciplines. And something that we learned at the NAID conference in Montreal back in 2011 from neurologists is that the ability to perform pattern recognition uses up to 30 parts of the brain. And that comes from a research article, yet she also confirmed that. She showed us this example here of how does the brain write. Something that was very interesting when we take request exemplars. We ask someone to write something. We ask someone to copy something or write the London letter or other types of ways of getting request writing. There's a problem with that. One of the problem is that the neurologist who gave us that presentation said that depending upon how we're writing determines what parts of the brain we're using. And what she said is that if we're just writing freehand, we use different parts of the brain than if we're copying, and we use otherwise if we're writing dictation, we're using different parts of the brain. So therefore, we may see different ways of writing depending on how the person was writing. So if we're sitting there asking for request exemplars and giving a dictation or saying copy, that writing might in fact look differently from the writing of just a freehand writing. So we have to be careful about that, and that's one reason why it's helpful for us to know the conditions the writing was under which the writing was made. A few years ago, I had a situation where we didn't have enough exemplars. I had to get exemplars from the person in prison. So we had additional exemplars that were request exemplars, and what I did in that situation is I received 60 request exemplars, threw away the first 30, figuring if the person's going to be trying to disguise writing, it would be in the first part rather than the last part. And the judge reduced my opinion from from strong probability to probably because they were request exemplars. Which is interesting. It still had the same effect on the case, but the point is that we have to be careful, depending upon how we're collecting the writing, to know what the results are of that writing. So when we say that we're a pattern recognition, the point I'm making with this slide is that almost every forensic discipline is a pattern recognition. If you're a nurse or a doctor, when you're making a diagnosis, you're making it based upon patterns that you recognize, patterns that are recorded in your literature for making a diagnosis. If you're a fingerprint person, you're looking at the ridge patterns, you're looking at other patterns and trying to come to a decision or an opinion based upon that. Fingerprint, by the way, has a lot of downsides in terms of the way they come to their opinions, because many fingerprint examiners only issue 3 opinions. One is, to use it in document examiner parlance, include, exclude, or inconclusive. They don't have the other opinions that we have, and which takes away a lot of opportunity for giving a better solution. In DNA, we're looking at the markers and asking, do the markers match? So in a sense, it's also a form of pattern recognition. It's not considered one of the pattern recognition disciplines, but it really is. And bite marks. Bite marks have been used to convict people such as Ted Bundy, yet there's a lot of question in the dental or in the odontology forensics as to the validity of bite marks, because the skin is very elastic. And the question is, how well does the skin, the elasticity of the skin, retain a bite mark? And how much is it distorted? How well can you really match that to someone's dental implant? So in the pattern recognition disciplines, we have to be careful, especially because 2 document examiners might see things differently. Andy Solner, who is on here, his grandfather, Julius Fischoff, came up with a very good approach, which is to take the examples, the question and the known, turn it upside down so you don't have the bias of trying to read it, and then ask the question, are there similarities or differences? If you're interested in that, you can read Andy's mother's book, Hannah Solner's book, where she goes into a good discussion of the Fischoff method. But that's another way of resolving some of these pattern recognition biases, is take a different look at it. Don't look at it just the way your brain would interpret it. Familiarity leads to thinking we understand something that we do not. And that's so true. I'm just going to throw this out and ask people just to answer the question. Can you tell me what the next number is in the sequence 246?
8.
That's one answer. Anyone else have a thought?
12.
Okay. What about 7? What about 24? So you don't have enough information here to you're all right. That's the point. You're all right. Because it may be just that the next number is larger than the previous number. That might be the answer. So all of you are right, and that's why we have, when we say familiarity and looking at it and saying 8, well, each number is 2 larger than the previous one, maybe. But 2 plus 4 is 6, and 4 plus 6 is 10, so maybe it's 10. And that's the point. We have to know what it is. What are we looking at, and how do we come up with the right answer? Because there may be multiple right answers. Here's a question, and I'll give you approximately a minute to come up with the answer. How many squares are in this picture?
17.
Do I have other answers?
22.
What was that?
22.
22. Okay. Anything else?
26.
Okay. Any other answers? I'm not telling you whether you're right or wrong. I'm just asking for people's. But you notice how we have all these people looking at the exact same question and no one got it right? The answer is 30. The answer is 30. If we look, there are 16 squares of 1 by 1. Let's look at 2s. There's a 2. There's a 2. There's a 2. So there's 3, and there's so there.
1, 2, 3, 4, 5, 6, 7.
6, and then there's and then 2s. There's 2, 2, 2. So there are 3, 3, 3, 3, 2s, which means there are 12 2s. There are, if we look at 3 by 3s, there's a 3 by 3. There's a 3 by 3. There's a 3 by 3 and another one, and then there's a 4 by 4. There are a total of 30. And I suggest you go and make one of these on your own and prove that answer.
Okay.
But you see, that's the point. We can all look at something and come that's written out that we can all hopefully get the same answer, and we all get different answers. And this is in essence what we're doing in document examination, handwriting comparison. We're trying to look and ask the question, what are we looking at? What are the commonalities? What's the right answer? And different people can come up with different answers on looking at the exact same image. And it's not that someone's trying to lie. It's we miss things.
Sure.
We miss things. And that's where we have to be very careful. And that's why a second set of eyes is oftentimes a good thing to have. So how do we frame a proposition? A proposition.
Decision.
Say that again, mate.
Sorry.
So can you mute your phone, whoever's phone's ringing? So when we say framing is the way a problem is stated, depending upon how that problem is posed to us, we may end up looking at the problem in a very different manner. Attorney says, my client signed this document and there's no question about it. Versus, can you look at this signature, we'll give you exemplars and determine whether or not my client signed it. Just the frame of saying my client signed it puts that into our head, whether we want it there or not, and there's plenty of evidence to support that. And the other part is old decisions are framed with new information. So therefore, people tend to look back and say, I should have known. But the point is, we come to our opinions based on the evidence we have, and sometimes we get new evidence and we have to come to a new opinion.
Mm-hmm.
We get new evidence. I mean, I had a case, I think it was last month, where I believe I had 29 exemplars from the person. All indications were showing this person did not sign this document. I got to exemplar number 30. My opinion changed. Because exemplar number 30 had many of the same attributes as the question signature. Other situations happen. I have a case where I had to tell the attorney it's completely inconclusive because on the document, one of the contracts that you gave to me where the person signed 5 or 6 times, he has 2 signatures, 2 different forms of his signature on the same page. Given that, I don't know if he has a 3rd form of his signature. So therefore, it's inconclusive. The exemplars, so sometimes what the answer is rather than when we see that there are unresolved differences, the answer is not necessarily that it's 2 different writers. The answer, it might be, we need more exemplars. We need more evidence. So we have to be careful on that. The failure of invariance, framing a statement poorly, can in fact come up with bad answers. And something that Carl Sagan said is that absence of evidence is not evidence of absence. Same thing that holds so true in our discipline. Just because you don't see the evidence doesn't mean that the evidence isn't there. If we got more exemplars, maybe we would actually see the answer. And rather than leaning toward exclusion, we may lean toward inclusion or identification. So we have to remember that just because we don't see the evidence doesn't mean that evidence doesn't exist. So when we anchor, we've already touched on this, so I won't go into it in any more depth. But the anchoring to how the question is framed can change how we view the case. So when we look at anchoring, how the trier of fact anchors to an inevitable solution to the case really may depend on how it's presented. Are they going to anchor to the expert's testimony or unnecessarily information? Will the cross-examiner be able to cause the anchor to go to a different place? So we have to really, really examine. That's why we have to tell a story. We have to be able to be basically salespeople of the evidence, sell people on the evidence, and try and do what we can to get away from that bias. Availability heuristic. If there's evidence out there, and that's one of the problems when we have trials where people have heard evidence and prior evidence is available to the jurors and trier of fact, we have to be careful because that may sway how people approach the problem. They may, in certain instances, say that, well, we don't see the same signatures in the exemplar, so therefore the person didn't write it. But therefore we may see a lot of similarities, and therefore the person did write it. Yet, if we remember what Ordway Hilton said, is that if there are significant unresolved differences, we need to lean toward 2 writers. Again, it may be we need to lean toward collecting more evidence. Contextual bias is really, really harmful. When we look at contextual bias, there's one researcher also spoke of contextual ignorance. And said that contextual ignorance may cause examiners to solve the wrong problem. There are certain situations where we need to know the context. We need to know under what circumstances was the writing made. We need to know under what circumstances did the person have drugs, did the person have injuries, and so on. As an example, these are two, and I won't tell you what my opinions were in these cases, but if we look on the left-hand side, we see the signature on the beneficiary. We also see the known signatures. Well, in this situation, I found out that the decedent had brain surgery between the time that the known signatures were written and when the question signature was written. Now, question, would you anticipate that brain surgery would cause the writing to change? Any thoughts?
Yes.
Okay, I hear a yes.
It could.
It could, certainly could.
Okay, and that's the right answer. See, I found out from the attorney what type of brain surgery the person had. I then did some research to find out, has any research been done on the effects of that brain surgery on handwriting? The answer was there had been. The research showed that that type of surgery had no effect on a person's writing. Because remember, we saw the pictures of the parts of the brain before, and none of those parts of the brain that are involved in writing were affected by operation on that brain tumor. So therefore, the question of whether or not there would be a change in the writing was there should not be any change in the writing because of brain surgery. The one on the right was a situation where you notice on the known signatures how much tremor there is in there. And I know, Reed, you've done quite a bit of research on tremor. But in this situation, the decedent was found in his apartment. He had been on the floor probably for several days, all dehydrated. He was taken to the hospital, and these two right here were written shortly after he arrived at the hospital. And then this signature was written contemporaneously with the question signature. But something I found out when I got the medical records and found out that one of the side effects of the drugs he was on for dehydration was tremor. So we would anticipate that he would have tremor in the question signature, and his writing also improved. As we saw, subsequently, the writing did improve as he became more and more hydrated. But again, the situation is context is sometimes very necessary because you had to know what brain surgery this person had, what medications this person had.
Also, it might have to do with the time of day he took the drug.
It may. Yeah, and I had all the medical records that had all that listed. But when we talk about adding details to information, if the detail is not important, we may tend to anchor on that. We may tend to focus on it. Here's a situation. This was a study published in Israel back in 2009. Three sets of practicing operating room or emergency room doctors were used in the study. They wanted to find out if they gave actual cases to the doctors and asked them to perform a diagnosis, what were the effects and how well could they perform on the diagnosis. Notice group 1 was given one misleading piece of information. They didn't know it was there. Group 2 was informed they were given one piece of information that was misleading, and group 3 was given only the details of the case with no misleading information. Down here, the results, it should say groups 2 and 3 diagnosed correct. I'm sorry, group 3 was 80% correct in diagnosis. They're the ones who were only given the facts of the case. Groups 1 and 2, it didn't matter whether the people knew there was misleading information or not. They only diagnosed correctly 10% of the time, 90% misdiagnosis. And these are practicing physicians. So the point is, we have to be careful that when we're given information, if we're given misleading information, it may cause us to come up with the wrong results. So why? Because they may have anchored to the wrong data, and the data that was available to them and the misleading information was something that was very common in thinking. So therefore, and if you go, you can Google that study and you can get it. You can just download it. It was very, very interesting. People also tend to be overconfident. The more we do something, the more overconfident we become in our ability to do it. There's plenty of research to show that. When I used to be in the information technology world, one of the biases of overconfidence of programmers, it asked them, how far are you on this project? I'm 80% there. Next week, how far are you? They're probably 70%. The next week, maybe they're 80%. You ask people, surveys have been done asking people, where do you rate yourself as a driver relative to other drivers? 80% of people rate themselves as above average. And that's just human nature. And so we have to be very careful when interviewing people also. Just the act of interviewing people can based upon the questions that are asked, can change the results. And something that's interesting, there's a book called Predictably Irrational. Something that's study that's cited in there is where people were given hypothetical questions and asked, how would you respond in this situation? Then they were put in those situations to see how they would really respond. Not one person responded the way they predicted. So therefore, in court, when you're asked, given this hypothetical, what would you say? You really have to be careful, because the answer is maybe you don't know. Maybe you just don't know. Confirmation bias is very deadly. Confirmation bias is where people tend to look for information to support their hypothesis and support what they think, rather than look at the evidence and look to weigh both sides. Something we can do to get away from this confirmation bias when we write our reports is to show what is the evidence that supports our hypothesis and supports our opinion, what's the evidence that doesn't support the opinion. Lay that out and then state, here's why the evidence on one side outweighs the other that led me to the opinion I have. Here's an example from a case that I had. Well, after we exchanged evidence, the other document examiner showed that he had 43 exemplars. In order to support his opinion that the decedent did not sign the will, he went and used 1, 2, 3, 4, 5 of the 43 exemplars in his report to show that the signatures could not have been the decedent. From the remaining 38, I was able to extract sufficient exemplars to show that his opinion was in fact incorrect and that every statement he made in his report was wrong, supported by his own exemplars. And this is an example of confirmation bias, where he was cherry picking in order to try and show the court the opinion that the attorney who retained him wanted to hear. Simon and Garfunkel said it very well in the song The Boxer: a man hears what he wants to hear and disregards the rest. So how do we overcome biases? This is really an important issue, because just knowing that there are biases, knowing that we have biases, that doesn't help to overcome it. We need to be able to get away from the subjectivity and get into objectivity in the way we do our reports and the way we do our work. One way to do that is to understand the concept of variability. We say that in handwriting, we're looking for variability. We're looking for how does the writing vary between the known and the question? What is the internal variability or intra-writer variability? And say, does the question fall within that? But to use only a subjective approach means it's not scientific, because scientific means it has to be repeatable. You have to be able to give a methodology that other people can repeat and come up with the same approach or the same result. So when it's all subjective, I mean, I remember one time in court listening to the other document examiner. The other document examiner was asked on cross-examination, is this objective or subjective? And he said, it's purely subjective. Well, if it's purely subjective, then that would be a reason why he would come up with one answer and three other document examiners might come up with three other answers, because it's just subjective. We have to have objectivity. And this is something that was interesting from an article by Thomas McAlexander from, I believe it was 1997 when he published it. He said public examiners stress similarities in order to identify, private examiners stress differences in order to eliminate. And that was from some research he did. Thomas McAlexander worked on the committee that helped write the ASTM standards. So when we look at a statistical approach, something that can be interesting here is that in this example I put together, the line width, meaning how long was the line, not the thickness of the line, but the length of the writing line in centimeters. And then for Q1, K1, K2, K3, we see that the average number of characters in the line was 18, 14, and 13, which came up to an average of 2.6 characters per centimeter in the questioned and also in 2 of the known. That's a good indicator showing, that's how we can show that the spacing is very similar. We can show that if we take the measurement and how many characters there are, we're showing that there's similar number of characters per centimeter. You can do it per inch or however, whatever measurement you want to use. But it's a way of using a quantitative measure to come up with an opinion. But we need to use quantitative measures. Here's an example from, this is from a case, I showed this in court. And what this is showing is this undulating line is showing the ratio, the angle of the S in Steve. And looking at it from here's the question writing. So these are the known, and we want to find out how far away is the question signature from the known signature statistically. We see that it's outside of 2 standard deviations, which means it's outside of approximately 98%, the way it shows here, chance that it was not written by that person. But this is a way of showing statistically, this is an indicator, it is not an eliminator or an inclusion. We need other evidence, but it's a good indicator from a quantitative perspective. Here's a situation where if we look at the questioned signature, it's right here, and this is the average of the knowns, which shows that statistically the question signature, the ratio of the middle zone to the upper zone is almost the same in the question signature as it is in the known signature. So statistically, we have a way of saying there's a good chance that this person did sign the will. Now, of course, we need other indicators. It is not conclusive. Had to turn the light on, Reed. You have a couple more hours of sunshine than we do.
I do?
Well, I mean, not time-wise, but from now.
Okay.
And May has a lot more hours to go. This is an example I used from a proficiency test where we know the answers, and I wanted to find out where do the data points lie relative to each other. I'm not going to get into the details on this with you. It's a little too complex, and we don't want a math lesson. There's a very good article by Jennifer Mnookin from UCLA, is the lead author. And I suggest you go read this article. It's very, very good. It was written in response to the 2009 American, I guess my brain's going. NAS, the National Academy of Sciences report. And what she clearly says is that we need a research approach, and she's not saying that all forensic practitioners need to be researchers and that all researchers need to be forensic practitioners, but what she's saying is that we need to have a research approach in order to make this work, in order to find out how do we go about a best practices in forensics, and how do we make it a quantitative approach. Now, as a result of the NAS study and the NAS report, the National Institutes for Standards and Technology and Department of Justice have gotten together and put together committees to form how do we go about the future of forensics. There are, I believe, 30 committees. Now, one of the problems I see is that if you look at the Committee on Document Examination, all the members are either practicing government document examiners or former government document examiners. There are no people like some of us here who are strictly from the private practitioner side. So from that perspective, there's probably bias in the committee. So talking about error rate, as we know, Rule 702 in the federal rules of evidence say you need to be able to show error rate. Is there anyone on the phone here or on this call who can tell me their error rate? Is there anyone who even knows their error rate? I would contend that none of us know our error rate because we don't get the feedback. We don't know.
Mike, is that something that could be determined through proficiency testing?
Not really.
No. Okay.
Because that's how did you perform on a test? That's not looking at the totality of your casework.
Yeah.
And to know that you got everything right on a test, that doesn't mean you get everything right on all your cases. There's someone out there. I'll tell you his name because he advertises it. His name is Jim Blanco, who advertises he has a 0 error rate. No one has a 0 error rate. And, anyone who claims to have a 0 error rate can probably be taken apart in cross-examination. And we're human. And in terms of what is our error rate across our industry, we don't know that either. We can know what the error rates are in terms of testing. We can see it in proficiency testing. We can see it in tests such as were done by Moshe Kam and Tawny Dewhurst down in Australia has done some testing on how well practicing document examiners do versus lay people. But
the other question is, if someone were asked any of us if we ever got anything wrong or how often they were wrong, we would never know, because a case may be decided with us or against us, but it's not a definitive answer if someone just makes a decision, a judge or a jury makes a decision on that.
Well, and also, Pat, no one ever makes decides on us. It's on how the attorney presents it. And I mean, as an example, I've gone to trials where I'm showing up on day 14 of a trial. You've probably had that too, which means that we're one little piece of the cog. We're not the answer.
Well, sometimes a judge will indicate that a certain expert was credible.
Right.
In the opinion that the judge gives.
Correct.
Decision.
But I know a situation where another document examiner told me that the judge said that the document examiner on the other side, he didn't find that person credible, but he ruled in favor of that side. So, which tells you it wasn't the document examiner that was the deciding factor. I had a case over the summer last year where it was a question, did the decedent sign a will? I said he probably did, yet the court ruled for the other side for a reason nothing to do with that. The reason they ruled for the other side is that the will was not in proper format for a California will. So even if the decedent signed it, it was not a valid will. Under California, whatever rules or define what a will has to say, has to be format-wise. Because in this case, they didn't have the two witnesses which are required. So, there are a lot of reasons why a case may go in favor of the side that retained us or against, but we may not be part of that decision. So we can't say it's our error rate. We don't know. So when we talk about error rate, we'll look at a situation. I'm not going to get into the math on this. If you print out the slides, you'll see the solution to this in the back in the supplemental slides. So I'm not going to go into it in detail. You can do that on your own. But the question I have here is, if we have two document examiners, and in one instance, one comes up with true positives in 98% of the cases and false positives in 2%, and so on. The question is, what's the error rate? Notice a false negative is 2%, you're getting 2% wrong. False positive, you're getting 2% wrong. Is the error rate 2%? It's not. Depending upon the situation, if you had 900 of 1,000 signatures from a common source, the answer is, and you got 2% wrong, you really got 0.23% wrong. If you had 100 from a common source and 900 were from a different source, meaning that they were not written by the person who supposedly wrote it, your error rate is really 16.51%, whereas in either case, it's showing as 2% error rate. And that's why when we talk about the question of error rate, you have to ask, what do you mean by error rate? Are you talking about how many times did I say the person wrote it and they really didn't? Or are you asking the question, how many times did they say they didn't and they really did? Or are you asking for a combination of the two? Those are three completely different answers to what's your error rate. So there's no, so that's why when asking the question of error rate from a mathematical perspective, that's an ambiguous question. You have to ask, what do you mean? False positives, false negatives, combination of the two. And the answer is, I don't know. So any final questions or thoughts? Just a quote from Jean-Paul Sartre. Politics is a science. You can demonstrate you're right and that others are wrong. No questions, no comments. Okay. So in conclusion, we've talked about different types of bias. We've talked about general bias, actual bias, advocate's bias, implied bias, judicial bias. We've talked about anchoring and the problem of different types of cognitive bias. We've talked about motivational bias, where we have to be careful that we don't fall into any of those traps. But how do we overcome bias? We overcome bias by taking a research approach to our cases. We look for ways to do quantitative analysis rather than just pure subjectivity, and being able to come up with good, repeatable methodology. Those are ways of overcoming bias. So, appreciate it. Have a duplicate slide there, and then we have you'll have your backup slides on here that will answer some of the problems that were given.
Thank you very much. It obviously put a lot of work into this.
I sure did.
And it's very helpful. Thank you.
You're
Maybe
welcome.
you can do a presentation, Mike, on how you did those graphs. Those are pretty incredible.
How I did what graphs? Oh,
The graphs showing the slants and the comparison of the question to the known, and you had all those graphs in there with all the.
Oh, I did that in Excel.
I mean, I have no idea what you did or how you did it or what it's all about, but it looks really impressive. And that's what I'd like to learn, maybe.
Oh,
Class on that.
Yeah, that would be good.
Oh, well, that's called a class on Excel, where you just take your Excel chart and screen sharing has stopped.
Maybe you could do a class on that sometime, because I think all of us would really benefit by that. I know I would. I've never done that kind of graphic before.
Do you use Excel?
No, that's what I'm saying to you. I would like to learn what you just presented. I think it's an incredible tool.
Oh,
Maybe
okay.
only one. I don't know. I just think it was an incredible tool.
Yeah, it's for doing that. I mean, I guess I could do something on that sometime. Sure.
Think about it and see what comes up.
Okay.
Thanks, everybody.
Mike,
Have a
thanks so
great
much.
Thank you. Good night.
Okay.
everybody.
Good night. Take care.
It's good night for me. It's something else for you.
Great.
Bye.
Okay.
See you next time.
See you. Okay. Take care.
Bye.
Bye.
Good night.
Night.